Welcome to the Truth About False Confessions podcast. I'm Alan Hirsch, chair of the Justice and Law Studies program at Williams College and an expert on false confessions. To learn more, visit my website, truthaboutfalseconfessions.com. Now on to today's episode. Most discussion of false confessions concerns coercive interrogations by law enforcement. But overzealous police are not the only cause of false confessions. The voluntary false confession involves someone freely confessing absent interrogative pressure. Voluntary false confessions, like false confessions elicited by law enforcement, are more common than most people would imagine. People voluntarily confess to crimes for all sorts of reasons, such as protecting the real culprit out of love or fear. A common motive is notoriety. Highly publicized crimes often witness people coming forward claiming to be the culprit. For example, more than 200 people confessed to kidnapping the Lindbergh baby. A more recent case in the news was John Mark Carr, who came forward and falsely confessed to killing the child beauty queen JonBenet Ramsey. In some cases, mental illness fuels or exacerbates a desire for notoriety, as may have been the case with Carr. A Swedish man confessed to 30 murders while in a mental institution and was convicted of 8. He was eventually cleared of all the murders. Most startling, a man in Texas, Henry Lee Lucas, gave voluntary false confessions to 600 homicides. Remarkably, Texas's official Lucas Task Force considered more than 200 homicides solved by virtue of Lucas's confessions, and he was formally convicted of 11. It was eventually determined that Lucas trolled law enforcement. In some cases, he confessed to 2 murders on the same day in different parts of the country. Lucas did indeed kill his mother, the case which led to his incarceration, but it is doubtful that he killed anyone else. Lucas may not have been a serial killer, but he was in a class by himself as a serial false confessor, and he knew exactly what he was doing. He received first-class treatment in prison. State and federal authorities often came to him to consult about murders he could solve by confessing. Lucas craved the attention, the fresh air that came with crime scene visits, the restaurant meals, the challenge of outsmarting law enforcement, and the notoriety that comes with being known as a prolific killer. Imagine my surprise when years ago, a case similar to Lucas's came my way. I will not name the man at the center of it because he remains on death row and his attorneys remain committed to keeping him alive. I will call him John Doe. John Doe was Henry Lee Lucas Light, an impressive serial false confessor, though he came up roughly 580 confessions short of Lucas's record. While John Doe was a scary, unsavory character, I felt no reluctance assisting him. The defense attorneys did not seek to free him. They sought only to prevent the state from executing him. As an opponent of the death penalty, I needed no persuading to get on board. John Doe was convicted of 3 homicides, but he confessed to many others, most of which he clearly did not commit. Law enforcement eventually acknowledged as much. All told, Doe confessed to 18 murders. He was undeniably guilty of 1, probably guilty of another, and indisputably innocent of 15. That left one case where his guilt was unclear. My primary job was to shed light on that case, one that could determine whether Doe lived or died. More than a decade ago, Doe was sentenced to death after a trial for the murder of someone we will call Jane Smith, an elderly woman. That Doe killed Smith was established by overwhelming evidence. During a series of interrogations with respect to the Smith homicide, he also confessed to murdering 2 women 10 years earlier. He was sentenced to death a second time after pleading guilty to one of those homicides. After pleading guilty to the other, a woman I will call Jenny Jones, he received a 65-year sentence. In seeking post-conviction relief for all 3 convictions, the defense was under no illusion that Doe would ever go free. But no state executes all murderers. For someone to be executed in Doe's state, like most states with the death penalty, there must be aggravating factors. Among the factors the state claimed with respect to Doe was his status as a habitual offender. If his attorneys could get any of these 3 convictions vacated, his death sentence might be commuted. For technical reasons, Doe's appellate lawyers, who retained me, did not directly argue that he was innocent of the murders. Rather, they argued that his trial attorney's failure to retain a false confessions expert, along with other missteps, amounted to ineffective assistance of counsel, which is grounds for vacating a conviction. I focused attention on Jenny Jones because Doe's actual innocence with respect to that crime seemed a real possibility. No physical evidence linked Doe to Jones's death. Also, there was another suspect who was not seriously investigated. Jenny Jones' mother told police that she feared for her daughter's safety because of Jenny's abusive boyfriend. And while Doe's many proven false confessions were given voluntarily, with him summoning law enforcement from his prison cell, his confession to killing Jones was the product of a problematic interrogation. The detective employed extensive minimization. She emphasized that Doe's psychological issues and alcoholism obviously pushed you over the edge. She downplayed the severity of his actions, calling them a mistake, and stating several times that "I'm not here to judge you." The detective assured Doe that if he fully confessed, the whole thing can be laid to rest and you can move on. The closest thing to corroboration of Doe's claim to killing Jenny Jones was him mentioning her tattoo and the location where he deposited her body. However, when first asked about any tattoos Jones may have had, Doe claimed no recollection. And while the investigators said that Doe took them to approximately the same area where her body was found, he acknowledged seeing television accounts where Jones's body was discovered. The evidence against Doe was thin. Doe told the authorities that he deposited his and Jones' clothing in a dumpster in a certain town where in fact bloody clothing was located. However, testing showed that the clothing in question belonged to neither Jones nor Doe. So too, Doe claimed that his tattoo, which consisted of a date, commemorated the day he killed Jones. Since she went missing close to the time of that date, police considered this significant. However, no evidence established that date as the date of her death. Her body was not discovered until months later, and an acquaintance of hers claimed to have seen her alive past the date in question. Moreover, that date is Doe's birthday. He turned 45 on that day, providing an innocent explanation for the tattoo. In other respects, Doe's statements contradicted the objective evidence. He claimed he stabbed Jones in the throat, causing her to bleed massively, yet the autopsy found no evidence of such a wound. Asphyxiation was the cause of death, and Doe described no action that would have produced that result. He repeatedly claimed that he stole Jones' ID, but that was never recovered. Improperly suggestive questioning permeated the interrogation and made it difficult to evaluate Doe's admissions. For example, shown a photograph of Jones and asked if he recognized her, Doe said no. Then told that the picture was at a gas station, thereby reminding him that the inquiry concerned Jones, he said, "I think that's Jenny." Under further prompting, he said, "I'm pretty sure." In general, Doe's recollection of the Jones murder was sporadic and uncertain. Shortly after acknowledging guilt, he wavered. "I don't know if it was me, but I could have done it." At one point, Doe explained that his suspicion that he killed Jones arose in part because his sister told him that she dreamed he had done so. He said, "I'm just thinking I must have done it. I mean, why would my sister dream it?" When asked how he had killed Jones, Doe replied, "I don't know, but my sister said she dreamed that I cut her throat." As the questioning continued, Doe asserted with gradually increasing conviction that he stabbed Jones in the throat. However, his narrative of the details of this crime was interspersed with statements like, "I must have done it," statements of inference rather than recollection. Doe's account also involved several changes and contradictions. At first, he claimed the victim's name was Monica. He said she was real small, but later said she was tall. Jenny Jones was 5'9". Doe initially said he killed her in a specific municipal parking lot, but later said it was in a hotel parking lot in a different town. My doubts about the veracity of Doe's confession to killing Jones was buttressed by him having incontestably given 15 false confessions to homicides. He gave elaborate, detailed, and gruesome accounts of some of these. For example, in one of his imagined homicides, he said he used a white-handled fish fillet knife. Doe went so far as to fabricate an accomplice, replete with a name, residence, and other specifics. The more I learned, the more I saw similarities between Doe and the notorious Henry Lee Lucas. Just as Texas law enforcement and later the FBI repeatedly came to Lucas to inquire about unsolved crimes, law enforcement showed Doe photographs of murder victims or missing persons and asked if he had anything to do with them. Just as Lucas was taken to crime scenes, Doe was taken to places where he claimed to have buried his victims. Whereas Lucas received various privileges, Doe enjoyed fresh coffee and cigarettes during his many meetings with the authorities. To add to my doubts about Doe's guilt with respect to the Jones murder, he was diagnosed with bipolar disorder. People with mental illness are vastly overrepresented in the population of false confessors. After submitting a report attesting to all of the above, I testified at a hearing. Months later, the Superior Court judge handed down a detailed opinion that appeared to take my testimony seriously. But she concluded that my testimony would not have influenced a jury, and thus it was not ineffective assistance for Doe's trial lawyer not to retain a confessions expert. This conclusion rested on disappointing reasoning. The judge wrote, "Petitioner Doe's expert on false confessions, Alan Hirsch, only criticized two of the detective's interrogation tactics, minimization and leading questions. Mr. Hirsch did not testify that he saw any significant confrontation of Petitioner Doe, a tactic used to convince a suspect that denying guilt is futile, and a tactic that, if used here, would make a far more convincing case for coercion." The judge was right that the detective leaned on minimization, not confrontation, in the effort to break down John Doe. But she was wrong to suggest that merely using half of the Reed technique is unproblematic. All told, she gave short shrift to my lengthy explanation of the reasons to doubt the reliability of Doe's confession. The Public Defender's Office appealed to the Court of Appeals and then the State Supreme Court. Despite defense counsel's best efforts, both courts affirmed Doe's conviction. The Court of Appeals quoted at length from my testimony at the hearing, but held that, despite this testimony, we are not convinced that Doe's counsel fell below an objective level of reasonableness by failing to retain a confessions expert. Their reasoning was unconvincing. The court said that Doe knew and communicated accurate facts about Jones, including that she had a distinct tattoo, and he was able to take the police to within 50 feet of where her body was found. For reasons I have explained, Doe's alleged knowledge was unimpressive, but at least the Court of Appeals took the possibility of a false confession seriously. By contrast, the Supreme Court opinion offered a single dismissive footnote with respect to the false confession aspect of the case. John Doe remains on death row. If he ends up executed, few tears will be shed. He brutally murdered Jane Smith. But insofar as courts continue to pay short shrift to the reality of false confessions, innocent people will be executed, as surely has happened given how many people on death row have been exonerated. Thank you for listening to this episode of the Truth About False Confessions podcast. I would greatly appreciate it if you would rate the podcast on Apple, Spotify, or whichever platform you used to listen.